Hello?
Hello.
Mr. Gardner.
Yes, this is Marcus Gardner.
Hello, Marcus Gardner.
Hello.
Okay, so you're good. We're gonna let you be unless you need for one of us to stay.
No, I don't think so, but hold on one second.
Can we need to adjust this on the show right here?
Pardon me?
Can we need to adjust this on, catch this corner?
It catches you while you're on there.
Yeah, you're on. It catches it. Okay.
Yeah.
That works. And what we'll do is if someone's going to be given a long soliloquy, they can go right where you are. So it's in the middle.
Right, okay.
But the way we've tried to structure it is, hold on. Get the YouTube up. Is that prosecutor stays put, defense attorney stays put, and the client is there in the middle. Unfortunately, with the old system, we would have to have people shuttle around because they couldn't all be there.
Oh, right. We can turn it just a little bit and then, because we don't really need to catch the front part.
And I don't need to see the big screen.
Right.
So if that helps,
Can you
Watch
push
the
it
we
key,
want
back?
to
watch your
rotate
power.
it more.
Oh, can you push that back?
Yeah.
Just angle a little bit. Then-
Yeah.
Yeah, that's good.
Okay.
Anything from Judge Ellaby's experience I should know? Like if a red light goes off, we duck and cover or?
No, I think if it's muted, I don't remember, I think if that's muted, it turns red.
Okay, but we don't have any way of, okay.
Sound is totally off now.
Us to do it, so we have.
Or did you have?
I
it?
did, yeah,
Okay.
do it also.
So I can mute it, but then someone's got to match the screen to
Yeah.
unmute it.
I
Okay,
mean it, yeah.
I won't mute it. Okay. We have something at 2 as well.
We'll be
Another
back
time.
here.
leave it.
So we'll just leave it?
Here, yeah.
Yep, sure, okay.
And we'll be back here,
I'll try to
42.
remember to let you all know when we're done with court.
Okay.
So
If you don't know words, we usually check about 4:30 anyway.
well, that's what happened.
Right,
Wednesday.
4:30, about 4:20, we can.
Start checking, so we
No
know.
problem.
what's going on.
Perfect. Okay, I'm excited.
All
I'll
right,
let you know.
all right, let us know. Thank you.
That's pretty awesome, Judge. Is this going to be something they have to set up each time, or is it going to be in each courtroom?
A great question. Right now, they have 3 of these devices. So it will be each time they set it up. If it is successful, maybe we'll try to get a few more. I don't think we'll end up getting 20. They're very expensive. But this seems to work a whole lot better than the previous setup. And it may be that some judges like the other setup and not this big screen, in which case fewer judges will be fighting for access to this kind of machine. But we should enjoy it while we have it.
Yeah, it looks nice.
All right, we're going to get started in about 30 seconds. That'll be 9:30. All right, let's get started. I'm going to do one more sound check. Mr. Forte, you can hear me?
Yes, Judge.
Great. Ms. Hall, can you hear me?
Yes, Your Honor.
Better than previous sessions or the same?
The same. Used to have a little echo in the back, but I can hear you.
Okay, good. No storms in your neighborhood right now?
Not right now.
Okay, great. All right. So this is the final plea calendar, and we are starting out with Mr. Gardner, who is online, but I am not seeing his attorney, Mr. Rosenblum. Mr. Gardner, is that still your attorney?
Yes, I actually spoke to Brandon Rosenblum about 15 minutes ago, and he's should be definitely joining the Zoom, I think.
He is just now. He just appeared.
Okay.
Morning, Your Honor.
Good morning, Mr. Rosenblum.
Sorry for my delay.
On the record then, please. Position 1 is 19 SC 166 725. It's State versus Gardner. We have Mr. Gardner appearing remotely. He's attorney. Mr. Rosenblum is with us, and Ms. Hall, the prosecutor, is with us. Mr. Rosenblum is charged with a couple, I'm sorry, Mr. Gardner is charged with a couple counts of aggravated assault, hit and run, and other offenses. Mr. Gardner, today is your final plea day. This is the day when we find out, hopefully you already know, what the state's offer is, and you let me know whether you're accepting that offer or if you're not, you want this case to go to trial. You're on bond for now, and we need to figure out how this case is going to move forward. Ms. Hall, is there any announcement you want to make from the state before I ask you what the state's offer is?
No, Your Honor.
Okay. Are you aware of any discovery issues remaining in the case?
No, Your Honor.
Okay. Well, what is the state's offer? If Mr. Gardner were to enter a plea today, what would the state be recommending?
For the top charge, the aggravated assault upon a public safety officer is 10 to serve 2, balance on probation. Everything else will fall under that. We are asking for restitution. I am waiting to hear back from Sandy Springs to get that total amount because a couple cars were damaged during this incident. I haven't gotten that amount from them as of yet.
Okay. So any conditions of probation beyond pay restitution of an unknown amount?
No, Your Honor, not at this time.
Okay. Do you have a ballpark estimate of the restitution, order of magnitude? Is it in the hundreds or the thousands or the tens of thousands?
I'm assuming that it's in the hundreds. It was just one car ramming into another, so there was damage done to the side of that car. I don't think that it reached the level of thousands. I expect it to be a couple hundred.
Okay. All right. Mr. Rosenblum, is that your understanding of the state's offer in this case?
Yes, Your Honor. Although I don't remember hearing anything about the restitution, I understand why that's an issue. We received this offer, this final offer last night around 5:30, 6 o'clock. I have had minimal time to talk to my client about it. What I would ask, Your Honor, if we keep the offer open just until Monday and make an announcement at that time, because it is a time issue. Mr. Gardner's also in Alabama right now because he's not working. He is under doctor's care for a heart condition. In fact, I don't know if the court is aware, I'm sure Ms. Hall is aware because I provided her with reams of medical. He had a heart attack during the incident and ended up having to have stents in his heart placed that day. So he's still under doctor's care because of that. We will likely be entering this plea under a non-negotiated stat and present evidence regarding his health conditions as well as his ongoing issues.
Okay, and there is no prohibition on non-negotiated pleas. What will change after the window closes on the final plea, whether that's today or, as you've asked, next Monday, is Mr. Gardner's ability to withdraw his plea if he is sentenced more severely than you advocate for, Mr. Rosenblum. So, Mr. Gardner, this is important. If, this is a hypothetical, you decide to go forward with a plea, whether it's today or next week or sometime, and the state asks for 10 to serve 2, balance probated, Mr. Rosenblum advocates for, I'm guessing it would be a probationary sentence, but whatever it is, if it's less than what the state asks for, if you entered your plea while we're under the umbrella of this final plea calendar, and I sentenced you to more than what Mr. Rosenblum asked for, you would be able to withdraw your plea on that basis. In other words, my lawyer asked for probation, judge, you're giving me 18 months, I'd rather go to trial. You'd have that right to back out, if you will, with no negative consequences, meaning the jury wouldn't hear about it, anything like that. After your final plea period is over, you still can enter a non-negotiated plea. You could do that on the day of trial. What you would not be able to do is back out of the plea if I sentenced you to more than what Mr. Rosenblum asked for. So same scenario, let's fast forward 3 months and you say, you know what, I need to work this case out. It's been hanging over my head. I want to enter a non-negotiated plea. State asked for 2 years. Mr. Rosenblum asked for no time served, and I give you a year in custody. You would be stuck with a year in custody. You'd not be able to back out if that's how things played out. Do you understand the distinction between tendering a plea before your final plea window closes versus tendering a plea afterwards, Mr. Gardner?
I think I do. I need to speak
Question.
with Brandon. I think I would need to speak with Brandon Rosenblum just to make sure, but I think I understand it.
Okay. Again, you're free to tender a non-negotiated plea, but if it's after we're done with the final plea, you just don't get it back out of it if you end up being dissatisfied with the sentence that I give you. Ms. Hall, any reason that Mr. Rosenblum didn't get this 10-serve-2 offer until 5 o'clock yesterday for a calendar that's been published since July 22?
Well, Your Honor, actually the offer has never changed from the state. Mr. Rosenblum asked me to further consider changing the offer. So I talked with my supervisor yesterday. She wasn't willing to, so we just kept the offer that was extended by my predecessor.
Okay, so your reaffirmation of 10-serve-2 was last night, but that's not a new figure for Mr. Gardner. In fact, that sounds like it's been constant.
Right, Your Honor.
And the
Okay.
problem, Your Honor, is this case has been bounced around between 3 or 4 different prosecutors in 2 different courtrooms. I've submitted all the medical documentation that Ms. Hall refers to 2 or 3, and I reached out to she reached out to me yesterday and asked me to send it again. So we didn't know whether or not we actually had a firm offer until that everything was considered until yesterday evening. And that's not on Ms. Hall. I understand this is a crazy time. Everybody has very limited access, and communication isn't exactly, stellar at the moment between anything. So I didn't know what to advise my client other than what I advised him a year ago, because we didn't know if everything had been considered. So I'm considering what the email from last night is to be the final offer, and that's fine. I just need an opportunity to really go over considering they are asking for time, an opportunity to really go through everything with my client, make sure he understands not only what is at risk, what final plea means, and you've explained it, and I can see Mr. Gardner's face that it is a lot to consider all of a sudden. That's why we're just asking until Monday afternoon, Monday before close of business, to give our final answer as far as that is concerned.
Okay, so your request is to be able to speak more with your client and let him think about it, confer with his family and loved ones and whatnot. And then by August 10th, close of business, 5 p.m. Eastern Standard Time. You would let Ms. Nelson and Ms. Hall, so my litigation manager and the prosecutor, know we would like to tender a plea, non-negotiated, negotiated. I'm indifferent on that part. Versus
whether or not to accept what the state's offering or take the risk of what a non-negotiated plea would entail.
So, Ms. Hall, I'm inclined to give Mr. Rosenblum and his client, Mr. Gardner, that additional time, unless you object, but I do need to cover a few of Mr. Gardner's rights now, because we're not going to reconvene everyone for this same conversation. If the answer by Monday at 5 is we're not entering a plea, then we'll put this case on a trial calendar. If the answer is that Mr. Gardner wants to go forward with a plea with the right to withdraw, because that right will expire at 5 on Monday the 10th, then all we need to do is set up a time to have that plea occur, and that we don't need to have all these other folks necessarily on the call. Are you all right with that, Ms. Hall?
I am, Your Honor.
Okay.
Thank you, Ms. Hall.
You're welcome.
Mr. Rosenblum, if Mr. Gardner were to tender a plea, would that be virtual like this? And if so, how do you envision it working if the ultimate sentence is one that involves custodial time?
I have no problem appearing in person and producing my client, be able to have, because my intention is, if this is a blind plea, we wanted to have enough time to get together any of our witnesses to provide information. So we would ask that it be set as a in-person plea. That way, in case there is anything, we can work out when custodial time would happen. Mr. Hall is currently unemployed, so he's in Alabama with his family, where he's receiving his medical care as well. I've advised him that he does need to get an updated report from his doctor regarding his current health condition as soon as possible.
Okay.
So I believe it to be an in-person. When the courts reopen for that type of thing, we move along to that, and that's my thinking.
Okay, well, we're open for that right now. So we would schedule it at a time that works for Mr. Gardner to get from Alabama to here and works with your schedule, et cetera. But no one should leave this discussion thinking, oh, well, if we say it's going to be a plea, we're not going to have to do anything for 3 months. It would be sometime in August that we would get everyone together to have that plea hearing. If that's Mr. Gardner's decision in the end. And I happen to have a very large courtroom, so we are able to accommodate folks with very safe, beyond 6 feet social distancing. We will take care of that if that's Mr. Gardner's decision. So Mr. Gardner, I need to cover with you a few of your rights that are associated with final plea, because we're not going to repeat this conversation. I'll just hear from Mr. Rosenblum by close of business on Monday, which way you're going, a plea or let's take this case to trial. So first of all, I need to make sure, Mr. Gardner, that you understand that the state's recommendation, if you were to enter a plea, is going to be that you serve 2 years in custody. You would get credit for any time you've already been in. I don't know if you ever went to jail for this case, but if you were in for a month, you get credit for that month. But the state would recommend 2 years custody followed by 8 years on probation. Do you understand what the state would be recommending?
Yes.
Your lawyer, because it's not a negotiated plea, would not be required to agree with that. Mr. Rosenblum would be free to recommend something different. I suspect it would be less and not more. And it sounds like he would be recommending that you not go to jail because of your health condition. You understand that because it's a non-negotiated plea, Mr. Rosenblum would be free to argue for a lesser sentence.
Yes.
I'm not bound by either recommendation. I could decide based on the facts and circumstances that you ought to go to jail for 5 years. And that's not what I think about this case. I don't know anything about the case, but I'm just letting you know that as I learn more about the case, which I will either during this plea hearing or at your trial, that I'm not constrained, confined by either the state's recommendation, that's not a ceiling for me, nor is Mr. Rosenblum's recommendation a floor, by which I mean I could sentence you to more than 2 years in prison, Mr. Rosenblum might recommend 5 years probation. I could sentence you to 1 year probation. That would also be a legal sentence. I'm not bound by either one. Do you understand that?
Yes.
Finally, Mr. Gardner, and this is what I explained before, but I need to make sure you understand it today. If you decide to go forward with a plea, by letting me know by 5 o'clock on Monday, then you will have the freedom, the right to withdraw your plea if you don't like the sentence I give you, if that sentence is more than what Mr. Rosenblum asked for. So if he asks for straight probation and I give you any time to serve at all, you would have the ability to say, no, thank you, Judge. I'd rather go to trial. And we say, all right, no harm, no foul. We'll move this case to a trial calendar. Do you understand that you have that right?
Yes.
If Mr. Rosenblum informs me and Ms. Hall by close of business on Monday that you are not going to be entering a plea in the near term and that you would rather go to trial, that right goes away. Your ability to say no thank you after you hear what the sentence is and back out of the plea. Do you understand that?
Yes.
Okay. And you and Mr. Rosenblum are free to talk about it more. And if he concludes that you didn't understand it, he can let me know and we'll work through that. But it's not meant to be a complicated notion. If you are pleading pursuant to this final plea, you can back out. If you are pleading 3 months down the road because you said, no, thank you, right now, I don't want to enter a plea. If you're pleading because we're calling your case to trial, you don't get a back out of your plea just because you don't like the sentence I give you. That's the only distinction. Last thing, Ms. Hall, I trust, is leaving open the offer of 10 serve 2 through whatever plea hearing we might have as a result of these discussions. Is that correct, Ms. Hall?
That's correct, Your Honor.
But, Mr. Gardner, if Mr. Rosenblum tells me Monday afternoon, nope, we are not going forward with a plea right now, the state may not ever again make you that offer. They might make you a better offer as time goes on. But you need to understand that the offer can expire and that you cannot, and I will not, hold the state to 10 serve 2 6 months from now just because they offered it now. So if you decide on the eve of your trial, wait a minute, I don't want a jury hearing what I did. I smashed into police cars or whatever the facts are. Again, I don't know them. I'd rather plead. The state may decide after they had to get ready for trial and they learn more about what happened that they're going to recommend 10 serve 3. And you don't get to say, wait a minute, no, I want that 10 serve 2. And you have to recommend that to the judge again. You understand that you don't have that authority?
Yes.
Okay, then I think you understand your rights. And if Mr. Rosenblum lets me and Ms. Hall know by 5 on Monday that you're not going to enter a plea at this time, some of those rights go away. And we'll move your case to a trial calendar. If instead Mr. Rosenblum says, Mr. Gardner's ready to enter a plea and put this behind him, then we'll set a date that works with your ability to get here to Atlanta and Mr. Rosenblum's schedule and Ms. Hall's schedule, and we'll do that plea hearing. It'll be sometime this month of August 2020. Do you understand that, Mr. Gardner?
Yes.
Mr. Rosenblum, I trust that Mr. Gardner is in Alabama with the green light of whatever bond was issued to him. I don't have that in front of me, but he's not in
I don't believe there was any travel restrictions, Your Honor. He's been out on bond for well over a year plus.
Okay. Then where he is fine with me. Mr. Rosenblum, anything else we need to cover before I excuse you and Mr. Gardner?
No, Your Honor, and just make sure everything's crystal clear. I do not anticipate this being a trial situation. However, just want to give my client the time we need just to really go over it, just to verify one last time, just concerning the what could possibly happen.
Okay, that's a fair request. This is Mr. Gardner's life on the line. And so the fact that he wants to think about it a little bit more and talk to you is a smart move. But I am going to put that limit on it that you have asked for, which is letting Ms. Nelson and Ms. Hall know. You can call, you can shoot an email, whatever's easiest, no later than 5 o'clock on Monday, August 10th, which way we're going. And when you do call or email, if the answer is we'd like to go forward with a plea, please also have ready your schedule and Mr. Gardner so that Ms. Nelson can engage you on how about August 19th, how about August 27th, whatever dates we're aware of that will work with our schedule and Ms. Hall. We already know Ms. Hall's schedule for August, so we'll need to know yours and Mr. Gardner's.
Thank you, Your Honor.
All right, Ms. Hall, anything else in Mr. Gardner's case?
Nothing else from the state, Your Honor.
All right, thank you, Mr. Gardner. Nice meeting you. And I will await word from Mr. Rosenblum. You all are free to go.
Okay, thank you, Your Honor.
Thank you.
So our second position is State versus Hart. I don't think we need to go on the record. I see Ms. Porter, who is Ms. Hart's lawyer. Were we expecting Ms. Hart, Ms. Porter, or because of the PTI understanding you all have, are you not expecting her to join us?
I'm not expecting her to join us, Your Honor. She just recently had surgery. And since Ms. Hall and I were able to work out the PTI situation, I don't expect that she'll be here.
Okay. Ms. Hall submitted the PTI agreement to me yesterday. It looks like the loan condition is that Ms. Hart complete a theft class. I don't know exactly what that is. I can guess based on the name of it, but I assume that that's something that is readily available so that over the next few months, it's something Ms. Hart can do.
I've worked with PTI previously, and they've been able to tailor a class like this for other clients of mine. So I anticipate that the PTI people should be able to get this done for us.
Okay. That looks like the one condition. I'll sign the order, which will move this case to the dead docket. And then the state will have until 1 month from that deadline, in other words, February 2, 2021, to bring the case back if they feel that Ms. Hart did not comply. Otherwise, it'll be dismissed for want of prosecution. My hope is instead, Ms. Hart completes it, gets the records to you, Ms. Porter, and you get it to Ms. Hall, and then it's actually not processed by the state. But one way or the other, the case will be either revived or resolved early next year. Ms. Hall, anything else in Ms. Hart's case?
Nothing further from the state, Your Honor.
Okay, Ms. Porter, anything else?
Nothing further, Your Honor.
Thank you for dialing in.
Thank you.
So our next position is not until 10. That's Mr. Hightower with Attorney Howard. Ms. Hall, my recollection on this one, and I guess the one that just preceded it, Ms. Hart, was that Ms. Porter and Mr. Howard were both very reassuring that they were sorting this case out. Has that changed for Ms. Hightower, or is it Mr. Hightower?
It's Ms. Hightower. I believe everything is the same. They just needed time to fill out the PTI paperwork. So nothing has changed as far as I know.
All right. So we should see Mr. Howard in a few minutes, and
Yes,
maybe Ms. Hightower, maybe not. But your understanding is that it's going to be something similar to Ms. Hart?
Yes, Your Honor.
Okay. All right. Well, I will plug back. I'm going to just be working right here, but I'll re-engage at a little before 10.
Okay, Your Honor.
Thanks.
You're welcome.
Okay, I got two of them for you.
Oh, people came back.
Oh, this was the first one that came in. Second one.
So Mr. Jackson needs to let us know what he's trying to do.
Okay.
So I don't know if he's trying to get a divorce or what. So if you could find out from him why he needs to be declared indigent. In other words, what he wants to do. This looks. So I think he's good to go. I just need to know what it is he needs this for.
Okay. All right. Okay, I'll get them back in.
Oh, yeah, they're welcome to be in the whole time. This is an open courtroom.
Okay.
Yeah, this is public. It's being streamed live on YouTube.
Okay.
Ma'am. Okay.
Yeah.
Are you Worthington?
I am, sir.
You are, okay. Hello.
Hi.
Do you swear or affirm that the contents of you're the evidence officer?
I am.
All right, contents of your affidavit are true and correct to the best of your belief and knowledge?
Yes, sir, I do.
Why does the office of, this is insurance commissioner's office?
Yes, sir.
Why do they end up seizing things? What would a scenario be where you'd end up with, say, my cell phone?
If you have evidence of maybe email exchanges, or you have communications with somebody whom you're conspiring with to commit insurance fraud, there's any communications, pictures, photographic evidence.
So you can do search warrants. You can.
Yes, sir.
Okay, that's what I meant. Not so much like why a cell phone versus something else.
Okay.
So why would you end up with that?
So methamphetamines came from an arson case. We also have an arson, we're in the house. So this particular case that we have the methamphetamine that was found in the anal cavity of him after autopsy.
Okay, that's one place to put it.
Yes.
All right, so you need to sign your affidavit, but I'm gonna sign the order first and then you'll have everything.
Thank you.
You're welcome. Will you be selling or destroying the drugs, but the other stuff?
Destroyed, sir.
Okay. All right, the order's on top. I sign that. If you'll just make sure you sign the affidavit before you go,
Yes, sir.
you'll be good to go. Sure.
All right, he's fine.
Okay. Mr. Jackson, what's the name of the person you're seeking to divorce from?
Lisa Jackson,
You spell that first name?
DALEISA.
Does Ms. Jackson still live in the metro Atlanta area?
Yes, sir.
Okay. Do you have that affidavit also?
Yes.
So is Ms. Jackson in Fulton County?
Eastern?
That's Fulton, okay, because you're not, so I just want to make sure you're not wasting your time filing in the wrong. She's in Fulton County.
Yes.
Okay.
We actually used to live together. I got us a house, but I let her keep it. So that's why my average should be 18, 20.
And this salary that you have listed here was from the job you had that you don't have anymore.
Yes.
Got it. And since that's why you provided unemployment for, which is perfect.
I work at the airport, but due to the whole COVID-19 thing.
I had to fly for the first time recently. There's no one there. I mean, there's not a lot of jobs up there.
They're trying to pick it back up, but
Yeah.
I don't see what's the purpose. If they don't have a cure for it and the numbers keep going up, just let everything be cool until
Oh, yeah.
we find something.
Amen. All right, good luck.
Thank you very much.
All right, I think we are at 10:01, so let's move to position 3 on our calendar, final plea calendar, which is State versus Hightower. I saw Mr. Howard, he's back, and I see Ms. Hightower. How you doing, Ms. Hightower? You're on mute, Ms. Hightower.
Hello. Good morning.
Good morning, Mr. Howard. You doing okay?
Yes, thank you, Judge. Doing just well. Thank you.
We need Ms. Hall to return, and then we'll be able to get started. Although, just to short circuit a little bit, my understanding, Mr. Howard, is that this is a PTI resolution.
Good morning, Judge. I'm sorry, Ms. Hall said that the internet kicked her off. She's trying to get back on.
Okay, good. We won't do anything formal. She had just told me, because we just handled a co-defendant of Ms. Hightower at the preceding position, and I asked for a preview of Ms. Hightower's case. Ms. Hall had indicated that the plan was PTI. Is that the plan from the defense side?
That is, Judge, and we've been in touch with PTI. She wants to avail herself of that. We just need to get her signed up, basically.
Okay. Well, let's let Ms. Hall get back on, and then we can make a plan.
She didn't say nothing. Just they gotta come pick it up on Saturday. They said they're gonna bring us a big order.
Ms. Rolak, do you have any update from, here's Ms. Hall.
She says she's coming.
I'm back.
All right, all that story about there being no storms and the internet doesn't work anyway, huh?
Sorry, AT&T.
Okay, no problem. We have Mr. Howard and his client, Ms. Hightower, on the call. And Mr. Howard confirmed that PTI is the way they want to go. I just want us to talk about logistics, because I thought the point of getting on the call today was that PTI would have been sorted out, as it was, for example, with Ms. Hart. So Mr. Howard, let me know what steps remain to get this nailed down.
Judge, I believe Miss Hightower just needs to meet with PTI, or I don't know if they do it remotely now. We used to do it in the courtroom, but obviously that's not happening. It's too much. She is working quite a bit. She's a manager of a store, and so she works a lot of overtime, and she still is working quite a bit. So I would just like to set up a time for her to come in and sign everything, unless she can sign it online, the documents.
Ms. Hall, had you spoken with Mr. Howard about a virtual PTI, or is the expectation that for Ms. Hightower, this was going to be through one of the, not the court's PTI programs, but the system's PTI program?
It was gonna be a normal PTI, most likely through AIM. That's my contact. Well, that's been my contact through this pandemic. I can reach out to her now, Miss Tracy, and give her Mr. Howard's information so that she can reach out. And as usual, we can do everything electronically if that's okay with the courts.
It works for me. I don't remember if it was a co-defendant in this case, but I know fairly recently, I'm blanking on the attorney's name, but we did it virtually, meaning.
That was the third co-defendant in this case, Mr. Terrence, I forget his last name, I'm sorry. He was a third co-defendant. He started the PTI. He did it last time we were in court, and he went ahead and did everything when we were in court.
Okay. Well, I know that in some cases I have received an electronic version of AIM's paperwork. The defendant signs it, the defense attorney signs it, it gets zapped around everywhere. And I may have signed the prosecutor's name with the prosecutor's permission, but why don't we do it that way? Mr. Howard, there are ways in which the connections can be made, maybe with Ms. Hightower not having to come down to court. I don't know. But I want that to happen sooner rather than later. This was the final plea date. And I recognize things are more complicated these days. But this is one that is, I think, a good opportunity for Ms. Hightower. Was there any need for the conditions to still be ironed out, or was there agreement in your mind, Ms. Hall, between you and Mr. Howard as to what the conditions of PTI were going to be?
In my mind, Your Honor, everything was ironed out. It was just a matter of his client confirming whether she wanted to do PTI.
Okay. And you're confirming that, Mr. Howard, that Ms. Hightower wants to do PTI?
Yes, sir.
Okay. So what's a reasonable deadline to give you, Mr. Howard, to get Ms. Hightower connected with AIM and get these forms emailed or faxed or however people want to do them, so we can get this going?
She is one of my few clients that are actually working more now probably than before. I don't know her schedule, but I will leave it to PTI to meet with her, because I think if I'm in the process, I'll just complicate it even more. So they can reach out to her directly. I would hope and do that way, if that's feasible.
So she does need to do that. Ms. Nelson, my litigation manager, can email the forms now. She has the forms that are used with AIM. So should she email those to you, Mr. Howard, or do you want to provide Ms. Nelson with Ms. Hightower's email address?
I would rather give the information to Ms. Nelson for Ms. Hightower. That way it's less complicated and I don't kind of clog up the system here.
Okay.
So is Ms. Hightower still on the line? She seems maybe frozen in time there. Is she hearing Ms. Hightower? Can you hear me? Can you hear me? I see you're off mute. There she is. Okay. You're breaking up a little bit. I
can't hear you.
Okay. I don't have. Let me throw up her email here real quick. I probably do have it actually right here. I'm sorry. Just give me 2 seconds, because I don't think she's breaking up a little bit. Yeah, it sounds like you're having some.
I can hear you.
Oh, okay. Now I can hear you. What is the best email to reach you at, Ms. Hightower?
Yeah, I can hear you. You can use my register. Can you hear me?
Yeah.
Hello?
Mr. Forte, you don't need to be taking this down.
I'm sorry, I'm at work. My building don't get any service. I'm sorry, I'm at work. My building don't get any service.
Okay, can I just do it? It's Lawan Hightower at Gmail, and Lawan is spelled Leijuan Hightower, just just like it sounds, Hightower at Gmail.
So no dots in there. It's just her name, first name, last name at gmail.com.
That's correct, Judge.
Well, we will email the forms to her. You will be copied on that email, Mr. Howard. Ms. Hall will be copied on that email. So there's no confusion about when they were sent. Then we need to make sure that this connection is made. What I'm going to do is give Ms. Hightower 1 week to get the paperwork completed. So by noon on the 13th, we need to, that paperwork needs to get to me.
Sounds good, Judge. If there's any hangups, I can be contacted as well, but the court has my email, brian@howard@arca.com.
JUANHHIGH.
Okay. So we'll do that. If you run into any issues with any of this, let Ms. Nelson know. But we should be able to make this happen. All right.
Okay, thank you, Judge. Appreciate it.
Anything else with Ms. Hightower's case?
Nothing further from the state, Your Honor.
All right, thank you. So, good morning, Mr. Franklin.
Good morning, Your Honor.
With this new setup, you're welcome to stand right there. You can stay at your desk. You can be seen and heard in any of those locations because the camera is actually on the top of that machine rather than a little laptop at the podium.
I'm so bringing them like.
It is. Yeah. Oh, okay. I didn't realize that. So the forms actually need to go to Mr. Howard because he has to complete some of the paperwork, but that'll be made clear in the email that he gets. Thank you, Ms. Nelson.
Mm-hmm.
All right. We're at about 3 minutes, but is that Ms. Weeks on the line?
No, I just got the phone where she should be logging on any second.
Okay.
And I stepped out as well. We have a resolution in weeks. We have a agreement. Just need your signature with permission of Ms. Hall. I have e-signed for her.
Okay.
Additionally, I have another agreement for a different, depending on the calendar, but we've been working on that case for a while as well.
Okay.
Judge, we've lost video of Mr. Franklin.
Wonder why the video's off. We'll get IT down here. Can you hear? I guess you can hear everyone.
I can hear, yes.
Okay. All right, so I have a question. There is someone on the call whose screen name is Prissy Tay. I'm trying to figure out who that is.
That's me, Fantasia.
Oh, okay, that's what I thought. The camera is small. All right, so Ms. Weeks is on. Then why don't we, I know there's not a way for you, Ms. Weeks, to see Mr. Franklin right now, but you're gonna be able to hear him. He's here in court, and he has handed me a document that will put your case on what we call the dead docket, which means we lost Ms. Hall again. Same deal, Ms. Rolak?
Yes, Judge.
Okay.
She's trying to come back on.
All right, bad technology day. We got this fancy stuff. You don't need to take any of this down, Mr. Forte. But Ms. Weeks, I'm gonna keep talking to you. Are you able to hear me?
Yes, I'm able to hear you.
Great. It sounds like you have agreed to pay a little bit of restitution. And if you do that, and you have until November 1 of this year to do that, so you got a few months to do that. If you take care of that, then the state is going to dismiss the charges against you. You understand that?
Yes, sir.
Okay. Mr. Franklin, I was reminded that Ms. Weeks still has a warrant for her.
Yeah.
What's going on with that? Because it's a little funky doing this. Hey, how you? And we have a warrant outstanding.
Part of our discussion with Ms. Hall, so she can get back on. When we spoke at the last court date, when we first realized it, we learned it was for a Henry Auto situation in Henry County. Ms. Hall was not trying to bring her into custody, so we would ask if the warrant, it's a pretrial warrant. He set aside, came about because that charge came while she was out.
The warrant is from our pretrial because while on pretrial release, new charges arose in Henry County.
Correct.
It's not a failure to appear from Henry County.
No.
Okay. All right. I'll get with Ms. Nelson on that and we'll work through that. So Ms. Weeks, we're just waiting for the prosecutor, Ms. Hall, to get back on this call. And then if she confirms what you and I just talked about, you'll be all set. You think you're gonna be able to pay the $288 between now and November 1?
Yes, sir. I just need the information today to go where to pay it at.
I was gonna talk to Ms. Hall about that. I believe we are supposed to have a cashier's check or a money order, and it's supposed to be out to the Fulton County DA's office, and then the DA's office then cuts.
We'll get it. So there's no contact between alleged victim and defendant. Okay.
I just need to confirm that, but I'm 99% sure.
Okay. Ms. Weeks, Mr. Franklin will let you know what to do. It's probably going to end up being like a money order or a cashier's check. But Mr. Franklin will give you those details, okay?
Okay.
Judge, Ms. Hall said she had to reboot her computer.
Okay. Ms. Hall may get to come into court more often.
Hello, everyone.
Oh, Ms. Hall, you're back.
Yes, Your Honor, I'm sorry.
That's okay. We were just saying we may get to see you more here in court if you keep having the technical issues. Hey, Ms. Hall, I spent a little time talking with Mr. Franklin, who's here in court. You can't see him right now because the camera stopped working. And with Ms. Weeks, who is on the call right now. And as I understand it, Ms. Weeks has agreed to pay restitution, a little less than $300. She has to do so by November 1 of this year. And I've got the virtual PTI agreement here in my hands. Is that your understanding?
Yes, Your Honor.
Hold on one second. What did you do to make that happen so we can do it next time?
In the Zoom, if you touch down here,
Yeah.
this was Xed out, somehow it stopped.
Okay. Oh, so it was a Zoom thing. It wasn't the equipment.
Yes,
We could just go into Zoom and restart video.
yes.
Okay.
I think perhaps as the, you might have be able to control it and maybe you, I don't know, something
Okay.
could have wigged with the touchscreen.
It'd be nice if I had control. All right, but it's working. Thank you for coming down. Problem resolved. So Ms. Hall, the question came up as to how Ms. Weeks is supposed to get the money where it's going. Is that something you and Mr. Franklin can sort out?
Yes, Your Honor.
Okay. Last question. Ms. Weeks has a warrant for her. It's from pretrial. She was on pretrial supervision when she got arrested for entering auto in Henry County. Mr. Franklin said that you and he spoke and that you were okay with that warrant being set aside since she was on pretrial supervision for this case, which is being resolved by PTI. Is that also correct?
That's correct, Your Honor.
Okay, good. Mr. Franklin, anything else for Ms. Weeks?
I do not believe so. I do not believe so.
Okay, Ms. Weeks, I'm going to sign this document. That'll move your case to what we call the dead docket. And then you just get together with Mr. Franklin about how you're going to pay that restitution, all right?
Yes, sir.
All right, take care.
Okay, thank you.
Our next case is not until 10:30. That's Mr. Foster. Do you think he's calling in or walking in?
He'll be calling in. I spoke to him yesterday. Let me call him.
All right.
I sent him a text not too long ago.
Ms. Hall, can you hear me?
I can.
Mr. Franklin also presented me with a VPTI document for Tammy Brooks, who is required to complete an anger management class and 10 hours of community service and needs to do so by December 1 of this year. Is that your understanding in Ms. Brooks's case?
Yes, Your Honor.
Okay, I'll sign that as well. I'm going to turn the screen off for a minute. I have some folks who've come in for presiding things. I'll come back on when we get Mr. Foster on.
You should see a couple boxes with some faces.
Is one person here for all the manila folders?
Join.
Or one of you guys? Okay. And then you're here for the non-manila folder thing? Who got here first? Maybe, okay. 3? 4? Oh, it's 4 folders, okay. Are they all the same case?
3.
Okay, 2 sets of facts. All right. Just to manage your expectations, we're going to take care. We only have one more position on this calendar. And is it going to be a complicated one?
It's a negotiated plea.
Okay. It'll take a little bit. When I'm done with that, I'll read these and we'll take care of them. So you're welcome to stay. I don't know if you're ready to sign. You also can drop them off and then I can get you virtually. But I'll take care of it before lunchtime. We just need to take care of Mr. Foster's case and then I'll get to this and then to yours. that work? Okay.
The meeting ID is 841-1004. 8654. Yeah. Does it not ask for password? 577. 794.
I know Josh Waits. He worked with me when I was a federal prosecutor. So I don't mind working on these, but if, for example, the case were assigned to me, it's not, I have to recuse just because he was the case agent. I think it's the same Josh Waits. I had cases involving slot machines, the electronic slot machines, and it had FBI, but it also, I think, had Josh Waits. You think I'm talking about the same person? Okay. So I don't mind looking at this, but I wanted to disclose that. Is that you do any heartburn? Who's the prosecutor? Yeah, just let them know. Again, if the case were ultimately assigned, would it be prosecuted in Fulton? Or you're here because what you want to search is in Fulton?
No, Your Honor, so I think the case would be prosecuted in the catalog, pressure on that yet.
Then it couldn't be my case anyway. Why don't you can ask from the AG's office to say that I have in the past worked with, I guess, former investigator Waits. Was he with local law enforcement first and then he was with Department of Revenue, or he's always been?
Yes, Your Honor, so he was with Clayton County PD for.
Yeah, that was my recollection because Tracy, the DA there was big on busting the virtual slot people. And that's how he got his expertise. I think he may even have transitioned while I was working with him. So I'm happy to review is that the 3 or the 1?
That's the 1.
The 1.
The 3 or 4.
Okay, this happened to be the one I picked up. So check with the prosecutor to explain that we were professional associates, didn't know outside of work. He was effectively the case agent on a couple of cases I did when I was a federal prosecutor. I don't think it's an issue for a search warrant, but I would recuse from the case. The nature is such that if he were being prosecuted, I shouldn't handle the case. And if they're okay with it, I will gladly review.
Thank you.
All right, and I see Sean Foster.
Yes, sir.
All right. It'll probably be easier for Mr. Forte if you are at the podium, since there's no one else in here, if you're all right with that.
Absolutely.
Okay.
And speak into the microphone, please.
The microphone may actually be on the device. Did they say the device talks to our sound system?
I didn't ask them that much about it.
See what happens here.
It's on.
Is it easier to hear me now? Did that change anything?
Not really.
Can you hear me?
I can hear you. The problem with the Zoom audio sometimes is that if you're going too fast when you're speaking, it'll run the words together and then I can't figure out what you're saying. So if you can go a little slower and just speak in the microphone, that will help me tremendously.
Yes, sir.
We're here to please. All right, Mr. Foster is connected. The lighting is ominous where he is. Mr. Foster, can you hear us? Because we cannot hear you right now. And we're going to need to be able to hear you. Can you hear us, Mr. Foster? Can you say something? I'll start looking at the other three. Hopefully I don't know that.
Hey, Mr. Foster, click your screen. There may be something at the bottom that says join audio. Do you see that? Is that just like a pair of headphones or something? Click that, and it should give you an option like call using internet or something like that. And let me know when you've done that.
Are you David Jones?
I'm not. David Jones.
Was the guy next to you?
Yes.
Okay, connecting the audio. Okay, give me a second. It says connecting the audio. Now say something. I hear you on the phone. I don't hear you on the screen, but it said connected the audio now.
Oh, that was better. Try again.
Trying to make sure the volume on your phone is up because it's showing that it's picking up audio, but we still can't hear you through the. Okay, but we can't hear you. Say something, Mr. Foster. How you doing? Mr. Forte, did that pick up at all?
Yes, I did hear that.
Okay, I'm here. Okay, I can.
Okay, you've got the arm strength to do that?
Yeah,
Okay. All right, well, let's try this. We'll go slowly. Mr. Foster, can you hear me? All right, I'm Judge McBurney, and my understanding is that you are prepared to enter a plea in your case today. Is that right? Okay. We're going to need you to speak up loudly when you are talking because we're having to feed what you say through Mr. Franklin's phone, through a microphone to the court reporter. So that's a bunch of connections, all right? All right, well, Mr. Foster, you have the right to be here in court with Mr. Franklin, but you are choosing to appear remotely. Is that correct? Yes, sir. Okay, so you waive your right to be in court with your lawyer? Yes, sir. All right. If at any time during our conversation you need to speak privately with Mr. Franklin, will you let me know? Yes, sir. Okay. Mr. Foster, you're about to enter a guilty plea. That means that Ms. Hall, the prosecutor, is going to need to put you under oath. Once you're under oath, it's important that you answer all questions truthfully and completely. It's also important that you let me know, or Mr. Franklin know, if you have questions of your own. Will you let us know if you have any questions? Yes, sir. All right. Ms. Hall, when you're ready.
You're muted, Ms. Hall.
Sorry, can y'all hear me now?
Yep.
Thank you, Your Honor. For the record, Your Honor, the state is amending count 2, fleeing and attempting to elude from the felony to the misdemeanor.
Okay.
Mr. Foster, can you please raise your right hand?
Raise your right hand.
Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth? What did he say?
He said, yes, ma'am, I do.
Okay. Can you please state your true, correct, and legal name?
State your full name.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? No, ma'am. Is there any medication that you normally take that you have not been given today?
Yes, ma'am. What type of medication do you normally take that you haven't taken today, Mr. Foster? Okay, so there's no medication that you need to take to understand what's going on today?
Okay. Mr. Foster, how old are you and how far have you gone in school? And how, okay. Are you able to read, write, and understand the English language? Do you understand that you've been charged with robbery, fleeing and attempting to elude, being reduced from a felony to a misdemeanor, and possession of marijuana with intent to distribute? Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial? Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment? Do you need more time to discuss this case with your attorney?
Do you need more time to discuss the case with me, your attorney?
Are you satisfied with your attorney's services? Counsel, do you waive formal reading of the indictment?
So wait.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, for purposes of this plea only.
Your Honor, are we moving forward on a copy of the indictment?
We are. I have the indictment right here in my hands.
Okay, thank you. Counsel, do you waive moving forward on a copy of the indictment?
So wait.
Mr. Foster, have you been arrested on these charges? I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We are not aware of any outstanding warrants related to this case.
Okay. Mr. Foster, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to? The minimum and maximum sentence for robbery is 1 to 20 years to serve. The minimum and maximum for fleeing and attempting to elude misdemeanor is 12 months to serve. And the minimum and maximum for possession of marijuana with intent to distribute is 1 to 10 years to serve. You understand? Okay. Mr. Foster, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for robbery, 3 years probation plus 100 hours community service, condition that, or I'm sorry, your probation will suspend after community service is complete. For the fleeing and attempting to elude charge, 12 months probation. And for possession of marijuana with intent to distribute, 3 years probation. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. You understand? Do you understand this is a guilty plea, which is permanently recorded on your criminal history? Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts? Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today? Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that you're not allowed to possess or use a firearm while on probation? Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, And this is true regardless of any advice by your attorney or anyone else. Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison? Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself? Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of robbery, fleeing and attempting to elude misdemeanor, and possession of marijuana with intent to distribute in indictment number 19 SC 171822? Yes, sir. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Is this guilty plea freely and voluntarily given on your part?
Yes, ma'am.
And you understand all the charges that that we're moving forward with against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Foster. Your Honor, the state is aware of 5 prior felony convictions by this defendant. The last one being out of Turner County, disposition date of October 2015 for theft by receiving stolen property. The other convictions date back to between 99 and 2008. Would you like me to list those, Your Honor?
You can just give me the nature of those convictions. In other words, what the lead offense was.
Yes, Your Honor. The conviction from 2008 is a false imprisonment out of Clayton County. The conviction from 2003 is a robbery out of Clayton County. The disposition from Fulton County is a theft by receiving stolen property, which was a gun in 99, and an automobile conviction from Clayton County in 99.
Okay. So, Ms. Crawford, are any of these cases active for Mr. Foster?
He only has an active case out of Turner County where he's on probation, but he doesn't have anything active for Fulton County.
She said that she acknowledged that you had active probation out of Turner County. Yeah, the judge is asking which one were active.
Where is Turner County?
Where exactly is Turner County? Where in the state? What is it near? South Georgia.
Okay. All right. Thank you, Ms. Crawford.
You're welcome.
Your Honor, had this case proceeded to trial, the state would have proven that on September the 11th, 2019, at 61 North Avenue, Atlanta, Georgia, in Fulton County, officers eventually arrested the defendant on for a robbery charge, Your Honor. The victim, Miss Courtney Brown, flagged down officers saying that as she was getting out of the defendant's vehicle, her purse was in the front seat of his vehicle, but before she could get her purse, the defendant sped off in his vehicle. Officers did try to, at one point, try to stop the defendant. He ran a red light at a high rate of speed. They were able to get the victim's phone and track where he was located. When they did find him, I believe he was in a club called Club One, I'm sorry. He was inside of a club. The officers found the victim's necklace in his front pocket. He did have the victim's phone, and the rest of her property was inside of the center console of his vehicle. When they searched that vehicle, looking for any of the victim's additional property, they were able to find 5 bags of marijuana. The defendant was arrested and charged accordingly. That is all from the state, Your Honor.
What is Mr. Foster, your understanding, Ms. Hall, of Mr. Foster's connection to Ms. Brown?
I actually do not know, Your Honor.
Pardon me?
I do not know what the connection is between the victim and the defendant.
I can feel it.
Okay, you'll fill that in a minute. So then give me your explanation for a probated sentence for a guy who has a robbery conviction already and who is on active probation for stealing something. There doesn't seem to be, he has this woman's necklace in his pocket. He's got her phone. He eludes the police, and he's got 5 bags of marijuana in his car for his 6th felony at age 40. Why is probation the state's view of a okay sentence in this case?
Your Honor, I know I probably should have a better answer for you, but this was a case that was worked out, that was not worked out with me, but worked out with my supervisor and defense counsel. I believe there were mitigating factors that was given to her. I'm not sure what that was. I was aware of what they negotiated. I apologize, so I do not know. Those are good questions, but I don't know why. I just went ahead with what was negotiated and agreed to. Okay, well, I bet Mr. Franklin can fill us in. We're going to try to get the screen working again. Okay, so I want you to know, Mr. Anjurman, we did the same thing, and an error message came up that said something about power from the computer.
Yeah, it said,
this is not on record, Mr. Forte.
It said that it wasn't connected to the camera or something like that.
Okay, I'll watch for it. Okay, because they did show us self-help, and so Mr. Franklin went right up there and mashed the same button you did. And then we got a Zoom error message that said unable to connect with video, something about, I'm at a weird angle, something about check the power to the computer.
Connection, it was a power issue, and they checked the connection to the computer. So I think it's kind of like timing out, like from lack of movement or lack of touching the screen or something.
Audio has been perfect throughout, but it's the second time the video shut off. When your team came down the first time, they said, just press these buttons. So we tried that and got that error message. Again, audio stayed fine, but the video was off. So we'll need to figure it out. Okay, thanks. All right, Mr. Franklin, why is 3 years probation and some community service the right outcome?
First, Sean, it's a good deal of community service. I know oftentimes you see we resolve cases with 10 or 15 hours or so. This is significantly more than that. I know.
Mr. Franklin, I'm not understanding you.
I'm sorry. I'll repeat everything. Typically, when we resolve cases, there is a shorter amount of community service, if any, that's attached. This is significantly more than what we would typically be able to reach in a negotiation. Additionally, though he has a more recent conviction in Turner County, I believe it was 2015, everything else is really dated. He has been doing well for the most part. He is employed. I know you're trying to figure out exactly where he was as he's zooming in.
He looks like he's in a bus.
He's a truck driver, so he's zooming from the cab of his truck.
That was one of my questions for him.
So he does that. He had been working at a construction company that did that for 2 years. I'm not sure if he's still doing that on the side, but he is a certified ride buster. He does rebar for buildings and bridges. So for all the things that he may have erred in much earlier in his life, fairly consistently, he's done the right thing since then.
Until September 11th.
And that situation, you know, I think we hear robbery, we have whatever image comes in our head. As you heard the fact pattern recited by Ms. Hall, the young woman is somebody he met either in the club or as they were exiting the club. They were sitting in the car talking, and from what I understand of the police report is speaking with Mr. Foster, she gets out of the car, gets into somebody else's car, and he takes off. There's some debate as to whether or not at the time he took off, if he knew that her purse was still in the car. But this is not a situation where a woman standing and you go and snatch the car. I would kind of equate it to more of a set of circumstances that if we were taking a bar exam and we say, what can we charge him? Technically, it fits the definition because she was in close proximity and it was a taking. I do think that there was a pretty good argument that this is more of just a death by taking, and we can argue over value, whether it would be misdemeanor or felony amount death by taking. However, we chose to more vigorously advocate against the felony fleeing and unduly charge for obvious reasons, being that it carries a mandatory minimum sentence. And that dealing with that will remove him from all the positive things that he is doing in terms of being productive, working, and being a contributing member to society.
A felony fleeing and elude has a mandatory sentence?
1 year or $5,000 fine.
Oh.
So we chose to litigate that issue, and once we're able to secure a reduction on that charge, and probation that will continue to let him live. Myself and Mr. Father felt it was in the best interest of all parties. Additionally, there was nothing that he kept. Everything was recovered by the police officers. And talking with Ms. Hall, I still think that there is, I guess, money that needs to be turned over from the police, but everything that I believe she said, hey, this is what was in the car, this is what I needed, was recovered through the course of investigation.
So there's no restitution that you're aware of?
Not that I'm aware of.
No restitution.
Okay. Anything about the marijuana? It was there.
It was there. I mean, there are lots of debates we can have about whether it should be charged as possession with intent or not. But again, kind of in law school example, the argument can be made, given what else was at risk.
So the club is, what's that, 61 North Avenue? It doesn't matter, I'm just curious.
I think the club was at 61 North Avenue, and I forget where he was. So he had parked the car and began walking. Cops, he had a really unique description. It was like red pants and something else. Cops saw him walking, and he was in the general area. Stopped and investigated. Everybody went out looking for the car. The car was located some blocks away.
So he wasn't, because he was found at the club, then they had to go to his car.
They had driven away from the club. The club is where he and the young woman were originally. I think through the course of driving, he ended up in the general area of the club, but he wasn't found at the club. He was found in the area walking, had the key to the car in his pocket and all the items in the car.
Okay. All right. Mr. Foster, can you hear me?
Mr. Foster, can you hear the judge? He said yes, I can hear now.
Okay. You'll need to hold that close to the microphone. Mr. Foster, how long have you been a truck driver? How long have you been a truck driver?
Going on 7 months.
Are you long haul or local?
Yes, sir, on the road.
He does long haul. I think he's physically in Texas at this moment.
How do you envision probation working with that?
I mean, he lives in Georgia, so he lives in Fulton County, so.
Probation needs to know if he's leaving the state, or do we need to bake that into probation that he's allowed to travel?
I would ask that be verbally expressly put in that he should be allowed to travel for work purposes, just to make sure there's not an issue.
Okay.
I know oftentimes people who I represent who do long haul driving are able to just tell their probation officer that's not something probation.
I don't want it to be a problem. That's why I'm fighting.
I would prefer us to make sure we have the language in there just to be safe.
Mr. Foster, do you also do construction work, or is that all done?
No, sir, I only do on the road trucking, that's it. No construction.
When you are at home, is that here in Fulton County?
Yes, sir.
Who else is in your household?
You said, yeah, did you say your mother?
Yeah, my mom, she stays in Plea County.
And that's where you stay?
I want to stay with a female friend of mine, sir. But my mother's my main address.
So the judge is asking because for probation purposes, we need to know which county you're gonna have to report to. And so they need to have an address where they know to check in with you. So we need to know where do you rest your head at when you are here? What's the most consistent and best address for you?
Okay, yeah, well, we keep it with my mom's address is
I'm not understanding him, Judge.
Okay, talk a little slower, okay?
Okay.
So
tell us your mom's address.
32 what?
3230.
3230.
Plains Drive, P-A-W-N-E-E.
P-A-W-N-E-E Drive.
It's Rex, Georgia.
Rex, Georgia.
It's
Okay.
373.
30273. Yeah. And I'm repeating just to make sure that the court reporter is getting everything that you're saying.
Mr. Foster, had you met the young woman before the night this happened?
Had you met this young woman the night before you met her this night?
No, never.
Have you seen her since?
Have you seen her since?
No, sir.
No, sir.
Where do you think you're going to do your community service?
What type of place was that?
It was was it a union?
Who was being helped by what you were doing? I think the judge wants some idea of what you may do. I know probation oftentimes has a list of places, but he wants to know what you prefer to do.
Well, I can get the list from the probation is just bad. Help out clean up and things like that, pick up trash, that's what they need me doing.
How often are you in the Atlanta area? interesting supervision. Okay. All right. Well, Mr. Foster, I find there's a factual basis for your plea. And I also find that your plea is knowing and voluntary. Knowing means you've understood what we've talked about. And if you didn't, you asked questions about it. Is that correct? Voluntary means no one's forcing you to enter this plea. It's what you think is the right way for you to move forward. Is that also correct? I'm sentencing you, Mr. Foster, pursuant to what's called the Probation Options Management Act. And all that means is that while you're on probation, if you have a small problem, what we call a technical violation, you and probation will sort that out. But if it is more significant, if you get arrested again, something like that, that comes back to me. So, Mr. Foster, I'm going to follow this joint recommendation. It sounds like when you were in your 20s, you got into a whole lot more trouble than when you got to your late 30s. I hope maybe you're wrapping it up now. Some of this is going to start interfering with your trucking license if you don't get your arms around it. Count one, your sentence is going to be 3 years to serve. I will probate that. Count two will be 12 months to serve, and count three will be 3 years to serve. Those will all run concurrently with each other. So you have 3 years, they'll be probated. A special condition of your probation is that you have no contact with Courtney, standard spelling, starting with the letter C, Courtney Brown, that's the young lady you were with that night. Another special condition is that you complete 100 hours of community service, and your probation will remain supervised probation until you complete those 100 hours. I'm also going to require that you submit to a drug and alcohol abuse evaluation. And if that expert determines you need any form of treatment, then that treatment will be part of your probation. And finally, I'll indicate on the sentence sheet that you are allowed to travel out of state for work. Ms. Hall, anything else in Mr. Foster's case?
Nothing further from the state, Your Honor.
Ms. Hall, do you authorize me to sign your name on the indictment?
Yes, Your Honor.
Mr. Foster, do you authorize Mr. Franklin to sign your name on the indictment?
Yes, sir.
All right. I'm going to have Mr. Franklin sign his name and your name, and he can make the notice on the indictment about count two being reduced. I don't know exactly how you do that. I think that's it. Mr. Franklin, anything else in Mr. Foster's case?
No, sir.
So, Mr. Foster, you need to talk with Ms. Crawford. She's one of the people on your screen. She is with probation. She will not be your probation officer, but she's going to tell you how you need to report to probation. You do not want to miss your first meeting with probation. If you miss that, I will sign a warrant for your arrest. And that's just going to be a big setback for you. So you two need to talk. You can put the phone up to your ear. You don't need to worry about the video. You just need to hear her, and she needs to be able to hear you so she gets your information, okay? All right. I guess they still need to keep talking, so I'll leave them on the call.
Yeah, he kicked all of us in another room. I was still in the line.
Should I kick them to another room or kick?
Oh, yeah, because I can still. I'll on my phone.
Okay, all right. Ms. Crawford, I'm going to move you and Mr. Foster to a breakout room, okay?
Okay.
Let me just join. Thank you.
All right. Don't go anywhere.
It's something about his audio, it's something on his.
Yeah, we couldn't get his audio to work, so Mr. Franklin had a good workaround of holding the phone there. All right, I sent the message. You should be able to join the breakout room. Mr. Foster, you may need to, you want me to add you to the room?
Yeah.
Okay. We are not having the hearing next week. I have to unfortunately go out of town. But you raised a great point. If it's going to be in person versus virtual, and I think that was potentially going to be in person.
Okay.
Then I would hope you could be in court, but distant, and folks could wear headphones.
We have that.
Yeah, I know we've got that equipment,
Yeah.
but I did see the email. That hearing has been postponed, and Ms. Nelson and I will talk with you about whether it's going to be in person or virtual, and then we'll adapt. But I got your point that if it is virtual, it has to be consecutive, cannot be contemporaneous.
Okay.
No, so it just slows it down.
We did a trial with this reader a week ago. Used this plug-in because we don't have that to teach. And it was frustrating for her, tiring for the interpreters,
Yeah.
for the witnesses, because we stopped after 5 hours and we didn't have to continue. That gives you an idea.
Yeah.
We're gonna do a motion and, you know.
Yeah. It's better just to have everyone in here.
If you can.
Yeah. Okay. All right. Let me get back to this.
Judge, I know you decided, these are the interpreters, my.
Sure. Just leave it right there. I'll sign it. All right. Mr. Foster, did you see something come up on your screen telling you to move to a breakout room?
He says he didn't see it.
I don't know exactly.
Mr. Foster's gonna come back in the main, we'll just do it.
Okay. All right, Ms. Hall, we'll see you at 2 o'clock.
Yes, sir.
Great, Mr. Forte, 2 o'clock. Ms. Rolak, 2 o'clock.
Yes, sir.
Thanks, everyone.
Judge,
Yes,
Judge.
before you hang us up, I couldn't hear Mr. Franklin, so we'll have to do it in the main room.
yeah, that's what he told me because Mr. Foster couldn't move over. So I just got everyone else off. I'm gonna get off. I have some folks here I need to deal with, but we'll keep you guys on this main one.
Okay.